Good morning, everyone. I Paribadaya.
And I'm Natta Malhotra. Welcome to one and all present here at Amity Law School's workshop on practice of arbitration and mediation and its emerging trends, organized by ADR Committee in association with AFI with ProBono Club, Department of Justice.
This workshop on the practice of arbitration and mediation and its emerging trends serves as a dynamic platform to equip legal professionals, academicians, and students with contemporary dispute resolutions skills. It enhances understanding of evolving ADR mechanisms, strengthens practical knowledge, and bridges the gap between traditional legal education and modern day industry practices. Such programs not only contribute to professional development but also elevate the standards of legal education, fostering a culture of innovation, efficiency, and excellence within the justice delivery system.
It is indeed a great honor to have such esteemed guests and legal experts with us today. We are confident that the session will be enriching, insightful for everyone present. To begin this insightful journey, I now invite our respected faculty coordinator, convener Dr. Shobita Srivastav for the welcome address.
Thank you so much, sir, for your kind words. Moving ahead, in the absentia of Professor Dr. Amit Jain, the Honorable Vice Chancellor of Amity University, Rajasthan, a visionary academic leader with an illustrious career, he has earlier served as the Pro Vice Chancellor and Dean, Faculty of Management. Dr. Jain held several distinguished positions, including Director, International Collaborations at Manipal University, Jaipur, and Visiting Professor at prestigious international universities in Australia, Hungary, and Slovakia.
It is a great honor to welcome Professor Dr. Anilji Variat, Director of Amity Law School, Jaipur, a distinguished academician and legal scholar. Dr. Variat has previously held several prestigious roles, including Chair Professor of Environmental Law and Director of the Center for Research in Criminal Justice. With over 2 decades of experience in the field of law, Dr. Variat is a specialist in constitutional law, corporate governance, international humanitarian law, and environmental law. He has authored 4 books and over 30 research publications and has successfully guided 3 PhD scholars. His insights have been presented before Parliamentary Standing Committee on the Clinical Establishment Bill, a true academic leader and visionary. We are delighted to have him among us today. Please join me in welcoming Professor Dr. Anil G. Varier.
Thank you. Hello, am I audible? Yeah. Okay. Thank you very much. First of all, I do not want to take much time. Uh, First of all, I take this opportunity to congratulate the organizing team for organizing such a workshop, that too on a topic of contemporary relevance. You know that the quality of justice dispensation system of any country is very, very important, not only for the domestic dispensation, but also when it comes to international trade, international investments, and all those things, especially when India is in the pace of fast developing. We need to have, it is necessary that we need to have, necessary to have a very quick, just and equitable justice dispensation system. The conventional method of litigation and the court system is not capable of handling the entire disputes, legal disputes. So, alternative dispute resolution is, in fact, need of the hour. The scholars and experts now, they do not call it as alternative dispute resolution. Rather, they prefer to call it as appropriate dispute resolution. That much importance it has gained, the arbitration, mediation, conciliation and all, especially with the mediation law coming into force. It has really revolutionized our dispute settlement mechanism. So, I congratulate the organizers once again for arranging for such a very, very valuable and thought-provoking deliberation. And I hope that all the participants will get benefit out of that. Wish you all the best and all success. Thank you very much.
Sir, ये मेरा काम.
Thank you, sir, for setting the tone of the workshop so perfectly. We are deeply honored to welcome our keynote speaker, the distinguished Professor Dr. KVS Sarma, Vice Chancellor of NLU, Assam. Professor Dr. KVS Sarma is distinguished legal academician and administrator, currently serving as Vice Chancellor of National Law University and Judicial Academy, Assam. Since August 7, 2024, with an illustrious career spanning over 3 decades, he has previously held key positions including Vice Chancellor of Maharashtra National Law University, Aurangabad, and Professor of Law at Nalsa University of Law, Hyderabad. His expertise spans consumer law, corporate governance, and arbitration, with notable appointments as panel arbitrator for SEBI and a presiding arbitrator in high-stakes commercial disputes. A prolific scholar and mentor, he has guided multiple PhD scholars and contributed extensively to legal research and reform in the country. Sir, kindly join us.
Am I audible?
Got the interruption, sir, but your mic is muted. Oh,
Am
okay.
I audible, madam? Am I
Yes, sir,
audible?
you are audible now.
Clarity is there? No disturbance, no? Any disturbance? Hello?
No, sir, there are no disturbance. Your voice is clear.
Okay, thank you then. First of all, I'm thankful to Dr. Anil Warrior and Dr. Srivastava for inviting me to address this August gathering. And today's topic, that is a workshop topic, is what you call emerging trends in mediation and arbitration. But the topic allotted to me is making India arbitration ready hub. Making India arbitration ready hub, procedural excellence and institutional strengthening. This is the topic the organizers allotted. So on this, some half an hour, they asked me to talk. And India aims to become a global arbitration hub by strengthening its arbitration ecosystem through legislative reforms, establishing dedicated arbitration centers, and promoting institutional arbitrations with the goal of becoming a preferred destination for international and domestic dispute resolution. Making India as the hub of international arbitration has been one of the pioneering initiatives of the Prime Minister Sri Narendra Modi led DMA government. Setting up of an independent and autonomous regime for institutionalized domestic and international arbitration are a step in this direction. Cabinet approves New Delhi India International Arbitration Center Bill 2019, undertakings of International Center for Alternative Dispute Resolution to be transferred to New Delhi International Arbitration Center with effect from 2nd March 2019. Making India as the hub of international arbitration has been one of the pioneering initiatives of the Prime Minister, and the benefits of institutionalized arbitration will be manifold for the government and its agency and to the parties to a dispute. This will result in quality experts being available in India and also an advantage in terms of cost incurred. It will facilitate India becoming a hub for institutional arbitration. The Indian Council of Arbitration was set up in 1965 at New Delhi. This was the first arbitration center and it is working very well. Today it is the only institution which is working effectively, India Council for Arbitration, and several other arbitrations also came into existence, but the number one institution is India Council for Arbitration, ICA. It was established in 1965 at New Delhi. 40 years later, the Nani Palkiwala Arbitration Center was established in 2005 in Chennai. This was followed by the establishment of Delhi International Arbitration Center in 2009. The Mumbai Center for International Arbitration was next to set up in 2016. The Indian Arbitration and Mediation Center in Hyderabad was established in 2021. The central government plans to set up an international arbitration center in Gift City, Gujarat. According to Mr. Talib, India's arbitration landscape is undergoing a significant transformation, with domestic arbitration centers making strides in establishing themselves as credible alternatives to international institutions. Nevertheless, concerns persist regarding the lack of robust arbitration culture, inadequate infrastructure, and the need for further legislative and judicial support. The government has taken steps to address these issues with the changes made to the Arbitration Conciliation Act in 2021. In 2022, just 6 years after its inception, the total value of disputes administered by the Mumbai Center for International Arbitration surpassed 1 billion, and it experienced a notable increase of over 20% in cases compared to the previous year. In 2016, the Maharashtra state government approved an institutional arbitration policy which mandate that all state government contracts involving over 50 million, what you call in Indian currency, should have an arbitration clause providing for institutional arbitration administered by a recognized institution. In 2017, it recognized the Mumbai Center for International Arbitration as one such center. In July 2023, the SEBI mandated the resolution of disputes with identified market institutions or participants either through online dispute resolution or through institutional arbitrations in India administered by Indian arbitration institutions. IIAC Chair Gupta is equally convinced of the benefit of institutional arbitration. International arbitrations have started making their way towards India either as a seat or as a venue. India offers cost-effective platforms for the parties to resolve their disputes. The Supreme Court struck down the unilateral appointment of arbitrators for being violative of fairness, impartiality, and equality principles. This means outcomes of arbitrations conducted in the last decade where one party appointed a sole arbitrator to resolve a dispute are unreasonable. Parties will not be able to unilaterally appoint arbitrators for disputes arising out of agreements where one party has the exclusive right to appoint the arbitrator. The consequence for the lending sector is that now there are millions of arbitral awards that are unenforceable and millions of agreements with the unilateral appointment clause where lenders can no longer appoint an arbitrator to resolve recovery disputes. Lenders would also not be able to ask their customers to choose from a panel of arbitrators curated by them. This narrows the legal remedies available to lenders to recover their dues and intensifies the pressure on them after RBI's recent crackdown on unsecured personal loans. A frequently proposed option is to approach courts for the appointment of arbitrators. Considering the burden this would place on the judicial system, this option seems impractical and inefficient. Nomination of arbitrators by institutional arbitration is the only effective proposition which has been endorsed by the judiciary and the legislature through amendments in 2015, 2019, and 2021, and those proposed in 2024. In institutional arbitration, proceedings are administered by a neutral institution, following its rules of procedure through an independent and impartial arbitral tribunal appointed from a panel of arbitrators maintained by such institution. This ensures that no party can exercise undue influence over the proceedings, including the appointment of arbitrator. As per the existing framework, only a physical institution administering arbitrations in the conventional format was contemplated. Such institutions were required to be designated by the Supreme Court or High Court to be considered as an arbitral institution. They were also required to be graded by the Arbitration Council of India, which is yet to be formed. Both these requirements have been done away with in the proposed amendments. The new definition advocates arbitral institutions that can conduct arbitrations independently based on their rules of procedure without the need for designation by the Supreme Court or High Court, so long as they do not intend to perform the function of a court in the appointment of arbitrators in ad hoc arbitrations. Amendments also embrace online dispute resolution, that is called ODR. This not only bolsters confidence in the use of tech for resolving disputes, but also establishes India as a global leader in ODR. This is an exclusive form of dispute resolution for investor grievances in the securities market mandated by SEBI. Not only is party autonomy upheld, but issues of independence and impartiality of the arbitrator are also addressed while ensuring speed and affordability of the arbitration proceedings. This approach ensures a fair appointment process and has the potential to significantly unburden the courts. Arbitration procedural excellence. How to improve the procedural aspects of arbitration? To enhance procedural excellence in Indian arbitration, several key areas need focus. These include strengthening the legal framework, improving institutional support, promoting best practices, and encouraging the appointment of skilled arbitrators. Strengthening the legal framework. How to strengthen the legal framework of the proceedings of the procedure of arbitration, conducting the proceedings of the arbitration. Amendment of the Arbitration and Conciliation Act 1996. The 2019 amendment aimed to streamline arbitration law and align it with global standards. Commercial Courts Act 2015, this act established special commercial courts to handle complex business disputes, including those related to arbitration, to expedite the process. Promoting institutional arbitration, encouraging the use of institutional arbitration centers like ICA and IICA can ensure standardized procedure and expertise. Reducing judicial intervention, minimizing judicial interference in the arbitration process, especially concerning award enforcement, is crucial to ensure the efficiency and effectiveness of arbitration. Ensuring the integrity of the process, implementing measures to protect the integrity of the arbitration process and ensure fairness for all parties involved. Improving institutional support, training and development of arbitrators, investing in training and development programs for arbitrators to enhance their skill and expertise. This is one important area the government should take care for giving training to the arbitrators, the candidates who are going to be appointed as arbitrators. Facilitating access to information and resources, providing parties and arbitration with access to comprehensive information and resources on arbitration procedures and best practices. Establishing dispute resolution hubs, creating dedicated dispute resolution hubs with modern infrastructure and technology to support the arbitration process. Promoting best practices, adopting internationally recognized standards, adoption and implementing internationally recognized standards for arbitration, such as the ancestral model law, to ensure consistency and predictability. Encouraging the use of mediation and conciliation, promoting the alternative dispute resolution mechanisms like mediation and conciliation to facilitate amicable settlements and reduce the need for formal arbitration. Developing a culture of transparency and fairness, encouraging transparency and fairness in the arbitration process to build a trust and confidence among parties. Encouraging the appointment of skilled arbitrators, promoting the India promise. This initiative aims to increase the representation of Indian arbitrators in international arbitrations, highlighting their skills and experience. Recognizing and promoting the expertise of Indian arbitrators, highlighting the skills and experience of Indian arbitrators to attract them to participate in international arbitrations. Developing a pool of highly qualified arbitrators, investing in training and development programs to build a pool of highly qualified arbitrators with expertise in various fields. By focusing on these key areas, India can significantly enhance the procedural excellence of its arbitration system, making it more attractive and reliable destination for both domestic and international business seeking to resolve disputes efficiently and effectively. To improve the conduct of arbitral proceedings, parties should proactively manage the process, including establishing realistic schedules and tailor-made procedures. Parties have to prepare schedule, and to that schedule, the parties should stick. If they don't stick, then even though if you make any number of changes, the advocates and parties are not sincere, then this procedure will fail. Arbitral tribunals should also play a key role in managing the case and ensuring equal treatment of all parties, while also fostering flexibility in the proceedings and encouraging timely decisions. Arbitrators, tribunals also must follow the timelines, otherwise the system will fail. Proactive case management, early engagement. Parties and the arbitral tribunal should collaborate early on to determine suitable procedures for the specific dispute. They have to identify the suitable procedure. They must stick down to that particular procedure and try to expedite the process and try to get the award as early as possible. Realistic schedules. Establish a realistic schedule from the outset and adhere to it unless there are compelling reasons for changes. Cost-effective procedures. Parties should work together to find procedures that balance efficiency and cost effectiveness, potentially limiting discovery of depositions. Facilitators. Consider using document production facilitators to streamline the process and minimize disputes. They have to appoint this what you call document production facilitators, some specialists to identify the documents and placing the documents before the tribunal. Next important thing is technology. Leverage technology such as video conferencing to reduce the need for physical presence and streamline witness testimony. Then arbitral tribunal's role. Proactive management. Tribunals should take a proactive role in managing the case from the beginning, ensuring efficiency and fairness. Equal treatment. Guarantee that all parties are treated with equality and given a fair opportunity to present their case. Timely decisions. Make timely decisions on procedural matters, ensuring the proceedings move forward efficiently. Flexibility. Recognize the need for flexibility in the proceedings and adapt to the specific circumstances of the case. What are the key areas of improvement? Document production. Streamline document production processes, potentially by limiting discovery requests or using facilitators. Expert testimony is also an important area. Consider regulating the role of party-appointed experts to ensure impartiality and efficiency. What are the steps to be taken with reference to interim measures? Ensure access to interim measures such as emergency arbitrators to address urgent issues during the proceedings. Ongoing review process. Take feedback. Solicit feedback from parties and arbitrators to identify areas of improvement in the arbitration process. Best practices to be adopted. Adopt best practices and lessons learned from other jurisdictions to continuously improve the efficiency and effectiveness of arbitration. 3 sessions for improving document production practice. What are those 3 sessions? The standard of relevant to the case and material to its outcome. In Article 3 of the IBA rules on taking of evidence should be more narrowly applied. That is relevant to the case and material to its outcome. This principle is the first principle. A request for a document unrelated to proving one's claim should be reviewed with greater cautions. If it is not relevant and the party is asking for what you call arbitrator to prove his case with the help of the document, then arbitrators must take maximum care before giving permission. The party should consider getting assistance from a document production facilitator. These are the 3 principles the tribunal should follow for admitting the documents. To explore the enforcement of arbitral awards when challenged, a streamlined procedure focused on interim measures and expedited review can be implemented. This includes a focused review process for challenger, potentially with expedited hearings, and a clear system for interim remedies like security deposit or injunctions while the challenge is pending. With reference to challenges, these precautions the arbitral tribunal should take. These amendments should be made in the Act with reference to these aspects. What are those? This includes focused review process for challenger, potentially with the expedited hearings, and a clear system for interim remedies like security deposit. In Consumer Protection Act, they provided the security deposit like that. Whenever any party challenges, the tribunal, the court should ask the party who is challenging to deposit the award money in the court. Or injunctions also when they challenge, the court or tribunal should ask for deposit of the what you call some money as a security. In case he loses, the tribunal or court can forfeit that and give it to the opposite party. Narrowed grounds for challenges. Limit the grounds for challenges and award to those that genuinely affects its validity or are explicitly provided for in the Arbitration Act. This could involve removing less critical grounds for appeal, like those based on procedural techniques. Very limited number of grounds should be given to challenge the awards. Now the grounds are so many, those grounds should be reduced. Expedited hearings. Establish a dedicated timeline for reviewing challenges, possibly with expedited hearings before a specialized court or panel. Instead of court, better to make an amendment in the Act to challenge the what you call award before a panel of arbitrators again selected by the parties. If they go to court, it will take years again. That's why K.K. Venugopal said previously only litigation, now arbitrate and then litigate. What they are doing, they are going for arbitration. In case any party loses the case, he is challenging the award on some flimsy ground, and courts are taking, because he can challenge the award before the district court to high court to Supreme Court. And again, decades are taking to. That's why foreign companies are not showing interest to come to India to decide their cases through arbitration. Focus on substances. Prioritize the review of the substantive issues of the award rather than dwelling on procedural details. Conditional stay enforcement. Instead of automatically staying the enforcement of the award, allow it to proceed conditionally. The challenging party could be required to deposit security, potentially in the form of a bond or bank guarantee, to cover the potential damages if the challenge is unsuccessful. Anti-suit injunctions. Grant anti-suit injunctions to prevent the challenging party from initiating or pursuing parallel litigation in other jurisdictions to challenge the award, which can cause delays and complications. Security deposits. The court could order the challenging party to deposit a portion of the award amount in escrow or a security deposit. This ensures that if the challenge fails, the award can be enforced quickly. Centralized enforcement court. Establish a dedicated court or a division within the existing court system to handle all arbitration-related matters, including enforcement, challenges, and interim measures. This would help to build expertise and ensure consistency in decision making. Electronic filing process. Utilize electronic filing and processing systems to streamline the enforcement process, reduce paperwork, and expedite the review of applications. Focus on quick resolutions. Emphasize the importance of swift and efficient resolution in the enforcement process, discouraging unnecessary delays and procedural obstacles. Amendment of Arbitration Act 1996. Amendment, that is, the Act, an amendment is required to incorporate these expedited procedures and provide for clear guidance on the ground for challenge and availability of interim remedies. Training and awareness. Provide training to judges and legal professionals on expedited enforcement procedures to ensure proper understanding and application. Public awareness. Increase public awareness about the arbitration process and the expedited enforcement procedures to encourage greater reliance on arbitration. By implementing these reforms, a more efficient and streamlined system can be established for enforcing arbitral awards even when they are challenged, thus enhancing the confidence and reliability of arbitration as a dispute resolution mechanism. Enforcement award power should be given to the Revenue Department or Income Tax Department, and the power should be given to them to recover the dues, like recovering taxes under areas of land revenue. Amendment should be made that challenging the award also should be before a panel of arbitrators selected by the parties, but not before the court. Only provision for one appeal should be provided, but that too before a panel selected by the arbitrators again. Timeline should be provided for these tribunals also to decide the cases. So if they make these changes, then we can attract even foreign parties also to come to India and opt for India as a seat of arbitration. I thank the organizers for giving the opportunity. Thank you one and all.
Thank you, sir, for a profound keynote address. We really look forward for your insightful session. Up next, we are delighted to welcome Ms. Sanghamitra Sahai. She is a dual qualified attorney licensed to practice in both New York State and India. She holds 2 Master of Laws (LLM) degrees from top US universities, specializing in intellectual property law and international arbitration. Her legal journey includes KNS Partners in India. Before she moved on to carve a unique and dynamic international career, Ma'am has worked with boutique US law firms and trillion-dollar tech company based in California. Today, she wears multiple hats, mentoring New York bar candidates and LLM students, building her own practice by advising Silicon Valley based VC backed startups and contributing meaningfully to the field of international arbitration through various platforms and engagements. Ma'am, we look forward to hearing more about your experience.
Hi everyone. Okay, thank you for the invite, and you guys can hear me, right?
Yes,
Yes,
ma'am.
ma'am.
Okay, perfect. So, firstly, thank you for the invite, and we are reserving the questions for the last, right? So let me just start with the presentation, and it's quite late here, so just please bear with me. I'm on the Eastern time in the US, and you guys can see my screen, right?
Yes, ma'am.
Yes, ma'am, it is visible.
Perfect. So I want to make this more of an interactive session. So, but I believe there are a lot of participants, so it may not be possible for me to answer while I go through uh, the presentation. So just drop in your questions in the chat, and we can definitely visit them once I'm done. Also, so very quickly, the tagline "International Arbitration and Its Magic World." The reason why it's Magic World is I'm a big fan of Harry Potter, and the way it's shown in Harry Potter, right? That it's one of its own kind, and you need to be very special to enter the world, and then once you enter the world, you never want to leave it, right? So that's how I think of international arbitration. And I'll start with my journey first. So just to give you guys a quick background about how international arbitration is perceived through my lens. And of course, everything is my opinion, so if you guys don't agree, it's fine. We're all lawyers, we can just have different opinions at times. I did my second master's in international arbitration from Washington D.C. It's a university called American University over here, and I took international arbitration courses. We had amazing professors, and when I had started the international arbitration LLM, I was, even though it was my second master's, I was still very excited about the prospect of entering the international arbitration field, given I have more of an international background. Did my first law study in India, then did in the US. So comparatively, from JD students over here, you can say I'm more international. And so over there, I did really good in my courses. I got a letter from one of the ICC secretaries, like a recommendation letter, which is he's one of the world's busiest arbitrators, Horacio Gregera Noun. And then I worked with a boutique law firm in Washington, D.C., specializing in investor state arbitration for roughly about 1.5 years. Along with that, I was doing an internship with an arbitral think tank called CPR. It's a International Institute for Conflict Prevention and Resolutions based out of New York. So that is the education part of it. The networking part of my journey was, which is very important if you want to win international arbitration, because it's a very small field. Uh, and most of the times you won't even get to know about the vacancies, because it's through word of mouth that people get to know about vacancies. They know someone, and then they refer that person, and that person gets hired. So it's a very small, very so legal industry itself is very small, and you can think that international arbitration itself is a smaller part of it. So you have to make sure that you're going for conferences, you're going for events, webinars. You have to build a network. That's one of the major things. Then secondly, I'm a member of an organization called Arbitral Women. It's focused on people like women. It's about a 30-year-old organization, and it's more like a mentorship organization. So you can join that if you're interested. But it's one of the organizations I'm part of. I'm also part of the Chartered Institute of Arbitrators and several other organizations. Also, the reason why I mentioned about networking and LinkedIn specifically, I've mentioned about over here is that um, when you are thinking about international arbitration, you cannot think about boundaries. You cannot think about that, oh, I'm sitting in India, I cannot talk to someone who's sitting in the US or UK or Singapore. You have to reach out to them, because that's how this world works, right? International arbitration, unless you have connects, unless you have a network internationally, it's much more difficult for you to penetrate the market. The example that I have given is that I was actually reaching out, doing cold messaging on LinkedIn, and I reached out to someone from Fresh Fields in Paris, and this person was very kind enough to be like, "Hey, I can speak with you in next half an hour," and that was probably one of the best informational interviews that I've ever had with this person. And he was actually on the hiring committee, so he told me a lot of things about how the hiring committee looks at the resume. So these things are very important when you're when you're specifically in an international arbitration. Now, certain qualities that you have to be very mindful of when you are in this field is, of course, you need to know legal research, drafting, arguing, all those basic things you need to know. But I have mentioned here mental qualities, right? Patience, perseverance, positivity. Um, this comes because the field is so restricted, the field is so small, that you have to be really patient. Like, there is no set path that you can follow, that, oh, you've done internship, you have done a course in that, and you'll definitely find a job. So definitely you have to be very patient with it. You have to keep doing these things over and over again. You have to network, you have to talk to people, you have to be updated with different international arbitration not regulations, because there are nothing like specific like that, but you have to be updated with, are there any new awards that are coming up, what countries are involved, what big companies from your jurisdiction are involved. And of course, you have to be open to relocation, because if you don't find a job in one part of the world, then you have to think about that. If there's a possibility for you to relocate, then you can think about it. Otherwise, then you are even limiting yourself. So that is a quick background of my experience in this field. Now I want to just go for what is arbitration. I'm not sure how many of you know what is arbitration, but my goal from this presentation is that I want to give you more practical side of the world than the theoretical side, because theoretical you can still learn about. Once you start practicing, you will learn about it. You can learn about it through your courses. But the practical side of it is something that I felt when I was out in the market looking for international arbitration jobs, that, oh, if I knew these things, then probably it would have made the journey comparatively easier for me. So just as a very quick background, what is arbitration? I choose to define it as sister of litigation. The parties choose how they want to resolve the disputes. They choose the number of arbitrators. They choose who the arbitrators are going to be. They actually choose the laws that have to be applicable, where they want the arbitration to take place, what law has to apply with respect to like the seat, because that makes a difference for enforcement of the award that we get. You can, in a fair manner, um, project what the costs involved will be. Arbitration, of course, is not cheap, because these arbitrators, the parties have to bear the costs, and then you have to pay the arbitral institutions that you are taking the services from, and then of course the lawyers. Companies prefer this more because they have documents that they don't want to go to in public eye. So that's why it's a very popular mode of resolving dispute in companies. And then of course they can choose, if they want, depending on the arbitral institution, that they can choose that if the award has to be public or private, or if they want like certain information from the award to be removed, and then the award can become public. So that's a quick what is arbitration. Now, of course, you're aware about the arbitral institutions, ICSID here in Washington, D.C., and it's part of the World Bank's dispute resolution. Then there's Permanent Court of Arbitration, International Chamber of Commerce, Stockholm, London Court, Hong Kong, Singapore, America. So these are the few ones that are quite popular. American Arbitration Association is more popular in the US, and JAMS Foundation also. They are considered by like smaller companies, or based on what kind of rules that they are providing, or what kind of arbitrators that they are providing. The arbitral institutions will choose them. The parties will choose one of the arbitral institutions. There are many more, but these are the few popular ones that I have listed over here. Then there are quite a few Indian arbitral institutions that are coming up. So Indian International Arbitration Center, I think Mumbai one was launched in 2016, if I'm not mistaken. Hyderabad was launched 2-3 years ago. So the international arbitration is also picking up in India. When I was in law school, honestly, I don't recall much about what arbitration was. We just started as part of the course, but didn't really think of a career in it, didn't really think about the prospects or the things that were required to be done to have a career in international arbitration. So it's a great thing that now the institutions are coming up, and it's bringing in more awareness amongst the students and the legal fraternity. Okay, so going again, there are two types of broadly arbitrations: domestic and international. Domestic is between companies within the same country. More or less, the way it is done will be similar. That whether it's a domestic arbitration happening in India or in the US or in Europe, anywhere. Then there are in international arbitration, you have two types. You can say it's between companies from different jurisdictions, and it is also something what is known as investor state arbitration. So this is what I worked in: investor state arbitration, where companies are investing in countries, and then a dispute arises, and then they have to decide where to go, how can they resolve the dispute, and how will the award be enforced. So it's an amazingly interesting field, but it's even smaller part of the international arbitration world. So investor state arbitration, uh, of course, because you need to have certain expertise, you need to understand the laws of the other country. So for example, an investor from the US, maybe they invest in Argentina, right? And Argentina suddenly, like when they want to invite the investors, they have certain policies. But once the investor has invested there, is building a dam over there, the government changes and the policies change. Now the investor is really badly affected by this. So what happens in that case? You of course can't go to Argentinian courts, because they may or may not be just in their ruling. That can happen. And so they have to choose maybe a set of arbitrators who will sit in Paris, and they will work on the laws, and then they will come up with an award. So that is what's investor state. The tip over here is work with law firms that do investor state arbitration. It is law firms have developed this niche that when countries or when companies are looking for hiring legal professionals to represent their cases, they prefer to go to experts, and not always, or when they are even like drafting their contracts or having their treaty discussions, it makes a difference to go to the experts, because they will know how to navigate through certain things. So we have read so many cases in the past that were drafted by lawyers, but because the dispute resolution clause was not clearly defined, what will be the things that have to be taken care of, it has completely messed up the situation for whichever party is sending the notice to arbitration. Then these are the popular places for you to start international arbitration in US, New York, Washington, DC, and Florida. These are with respect to, I'm talking about international commercial arbitration or investor state arbitration also. The reason why I've mentioned only these three places is because coming from an international perspective, it is you have to deal with many other problems rather than just getting into the field. So for example, given the administration, you may have to deal with visa issues, right? And these, because they are California also has international arbitration, but it's more focused on international commercial side than investor state. New York in the US has a lot of firms. A lot of firms over here will have dispute resolution departments, and they will deal with different kinds of cases based out of South America or Europe. Generally law firms in the US, they will very rarely cater to Southeast Asia or India as their clients or companies. There are few, like Three Crowns is one that has certain number of cases with or against India. White and Case is other one, but other law firms like Freshfields, their Europe office or their Singapore office will deal with cases which are originating from Southeast Asia. So that's why this New York, Washington D.C., Florida becomes a restricted area for people who are coming from India. London can be much more attractive. London, Europe, Paris, Switzerland. These are much more attractive and much more easy to navigate through, because the law firms that you'll find over there, even the bigger ones or the boutique law firms, because they are catering to clients in India, and they are catering to Indian government, or they are catering to that industry, that geography of the world. They have more vacancies, and it's easier to get into those markets. Now, for US, of course, I have more experience with US, so a little more detail over here. When you're thinking about arbitration or entering into international arbitration in the US market, the market comes later. Before that, you have to think about visa. If you come here to study and then you find a job, then however you're coming to the US, visa is an important issue that you have to resolve. Now, with respect to bar, you need to, like, to practice law in the US, you need to be enrolled with one of the states, either New York bar or California bar. They are the most popular ones with international students. But to practice international arbitration, you don't require a bar, because you may not be practicing in the US. So the law firm that I interned with in DC, the main partner, he was not barred in the US. I mean, he did not have an enrollment in the US. He was from Argentina, and he had enrollment over there. So this may or may not be that big of a problem. It may serve as a entry point for you, just to get your foot in the door in the legal market, but it's not necessary if you're going into international arbitration. US, the market is really saturated, because there are JD students, there are LLM students, and it's the pathway for international students to enter the legal market itself is not defined, as it is much better in Europe or in London. That's why it's a very small market for international students. Vacancies are barely advertised. You may have a professor who knows of someone, and if you have a good professional relationship with the professor, they may recommend you, and then you can get in. And that also happens, that if that company, if the law firm has a client where you will be useful. So I once spoke with someone who works with Three Crowns. He's an Indian, and he said that he got the job through luck, because while he was doing his externship, the law firm had a client who with whom, like, on whose matter this person worked. And when they graduated from LLM, because the client wanted to save money, so they said that, why don't you call that student back, and I can save money. So that's how he got a job. So these are, like, very crazy stories that you will hear about US job market, irrespective of you in trying to enter into international arbitration. But comparatively, in Florida and DC, it's much more difficult than New York. One major thing which I didn't know about, and I really hoped someone would have told me, was that language is a barrier. English is, everyone knows English over here, right? So you are not bringing in anything new, or by applying for an international arbitration position. So very commonly, because Washington DC law firms and Florida law firms, their clientele is South America or Spanish speaking countries. They have more requirement for people who are speaking Spanish. Now, my obvious question over there was that why not learn Spanish? Of course, you can learn Spanish, but no one is going to hire you because you learn Spanish over a native Spanish speaker, right? So that becomes a major hurdle. French is also one of the major, because a lot of cases are there in Europe and in Paris, and a lot of African countries also speak French. So that is also a plus point. Um, I had spoken once with someone who's working with Reed and Smith now in London, and she learned French. She speaks French very fluently, but she said that it never helped her in office. Like, it'll be great for you to communicate, build a relationship with your office colleagues, but no one is going to give you work because you know French. So language barrier is one of the major things over here. New York, it's comparatively lesser, but with DC and Florida, there is a lot of a lot of law firms that are dealing with clients based out of South America. Now, again, this I've already covered, that most clients are based in South America, so that's why the requirement for international students or international arbitration practitioners in this area is much lesser. Where to start? I think UK, Singapore, Europe may be an amazing place to start. There are very good law schools or universities offering international arbitration courses in Europe. Um, and of course, this may not be applicable to you if you don't want to expend that kind of resources into going into LLM, but it definitely is one of the pathways that students or practitioners take to enter the international market. LLMs are, you can think of like a foot in the door into the legal market of any other world than India. So UK, Singapore, Europe, they have high likelihood of you over there. You have high likelihood of finding a job because they are working with Indian companies, Indian clients. The market is more accepting. They have something which is very critical and is missing with the US market is traineeship contracts. So this is like your 6-month internship. And it's comparatively easier to get into the market because once you apply, they always release, all these law firms, they release the application period that for September to December internship traineeship period, they will advertise maybe in January of that year. So I'm not sure about the time period, but you can check it on the law firm's websites if you're interested. And that helps to firstly know that you suited for that market or not. And even if you don't get that, so for example, you get a traineeship contract with Fresh Fields in France, okay, you work with them, but they are not able to hire you. But that having that Fresh Fields traineeship contract on your resume may be very helpful for you in finding a job, maybe with a bigger law firm in France itself, or maybe in UK, maybe any other country in Europe or Singapore. US, it may or may not help. They're not very accepting that way, and but it will definitely open more doors for you. So traineeship contract is something that definitely, if you're interested in Europe, you should look at. Same way it works in UK also. And again, if you have done an internship or a traineeship with Fresh Fields for 6 months, a boutique law firm may be more willing to hire you. Vacancies are published. Through my experience, what I've seen is, like, generally all the law firms, they seem to publish those vacancies. I never seem to find them in the US, but it's available, of course, for this region. Language barriers may exist in Paris. You may be expected to know French. Like in Germany, I've seen a lot of posts about international arbitration which require you to speak German. But again, it's not like you will not be able to get into it at all. Then, okay, so how to start an international arbitration? So this is the part which I really feel should be discussed with anyone who's thinking about entering into international arbitration. So tribunal secretary is something that I actually got to know after I graduated from my international arbitration. This is an amazing opportunity. What a tribunal secretary does is like a law clerk. They will sit with, and the tribunal secretary's role is defined by the arbitral panel. So they will define that how much work will the tribunal secretary be doing, how much their hourly wages, or they are getting like how much salary they are going to get for that particular arbitration, what kind of work? Is it only research? Is it only coordinating with the parties, or is it actually some of the arbitrators prefer that you write certain parts of the award? So it's an amazing opportunity to get yourself exposed to international arbitration, and also it's amazing to build your network, because once you're working with an arbitrator who's trusting you with doing their part of the job a little bit, they definitely hold you in high regard. Recently, I think end of December 2023, this tribunal secretary platform was launched by Use Connect. It's fairly new, and but there are a lot of tribunal secretaries who have listed themselves over there. Uh, Arbitrators can go and find themselves over there, and they can, you may be very useful for someone who has a case in India but doesn't understand the language. So an arbitrator from the US may be looking for something like local laws or something like that, where you may be very useful. So that's why they can do filter search, and it's very good. You can enroll yourself now, and it's free of cost. You can just send them an email. They just require you to have a professional email. But if you don't have a professional email, you can request them that, hey, I do have an international or an arbitration background, and this is how I want to get in. In the with the Mumbai Arbitration Center also, they have tribunal secretary course. Sorry. And that is again a good way to understand that, is that a field meant for you. First, second, if you want exposure, because again, these small building blocks are going to help you go the long way. I had a professor at my second master's who majorly works as a tribunal secretary, and she has a lot of experience. She worked with ICSID for about 6 to 7 years. She worked with Fresh Fields for 3 years, but now she does arbitration. She works as an arbitrator in like maybe smaller cases, but she coordinates. Her main job is as tribunal secretary, and I was surprised to see that someone who has that much experience, why would they go for it? But it's an amazing opportunity, because you're building the network. It's giving you a lot of freedom to work and to build your network. Now, for you to this may happen through these platforms, or you can just reach out to independent arbitrators. You can find the lists of those arbitrators. Like the platform I use is JAMS. JAMS is an American arbitral institution. You can just go on their website and look for the arbitrators. So it actually lists down the. I can share the screen if you want me to show it, but I'm not sure how much time I would have. So in the end, I can maybe show it to you. So with JAMS, you can find international arbitrators, or arbitrators who are like maybe of some interest to you, that they are working in specific fields. Send them an email, maybe get a call with them, schedule a call with them, or you can ask them for an opportunity that, hey, I'm working in this field, or I am a student, or I'm at whatever phase of your career you are in. You can just reach out to them, get a online coffee, which is basically you schedule a call with them, and they'll be able to share their experience. So people are pretty open about reaching out that way. Again, there's another way to find out about independent arbitrators is through different cases. So if you're reading ICSID cases, if you're reading PCA cases, they definitely list down the arbitrators' names. So from there also you can pick out and reach out to them. Maybe they have a current tribunal secretary whom you can get in touch with and find opportunities, or something like that. You can work out. So that is an amazing way to connect to this network of tribunal secretaries. Same as in, you can work as a law clerk. Some people don't want to give you the tribunal secretary role, so they may be open to hiring you like a research intern or something like that. So traineeship contracts are already covered with UK Europe. Internships with organizations like ICSID, ICC, PCA, Permanent Court of Arbitration. These are amazing because they are again giving you a wider platform. You are seeing the world from the other side, which is really valued by law firms. The reason for that is because, so I'll share this experience. Someone told me they interned with ICSID for about 3 or 4 months, and then they were immediately after that they were hired by one of the top arbitration firms in the US, Arnold Porter. The reason why the firm hired this person was that because they had worked with ICSID, they knew how the internal functioning of ICSID was. So it was much easier for this person to reach out to his network in ICSID to get, filings and all that information and all like basic things done, which if you don't have someone or if you don't know that the working of it from within, it may get a bit difficult. So that's why these are kind of like, think about it like if you intern with a Supreme Court judge, something like that. So this is amazing. It's of course very competitive, and they keep releasing different at different times when the internships will become available. So you have to take care of these websites. And then boutique law firms are again more open. You get more hands-on experience. You may actually be able to argue cases, which may not happen until a very later stage in your career with a big law firm. But you will get more experience with them. Maybe you get to travel also with the team, with your partner, depending on how much the budget is for that case. One thing I wanted to point out over here is that travel is definitely a very in investor state arbitration, it seems like a very enticing opportunity to, oh, you'll get to travel, you'll get to, maybe travel to Paris, you'll travel to London to represent clients and stuff like that. It may or may not happen. So when you're looking at this world from outside, it may sound very very fancy, but in the beginning of your career you may not necessarily get to travel. So just that's a very common misconception that students or early practitioners have. So just a anecdote over there. Okay, so how do you start with this? There are a number of organizations that you can become members of. So Charter Institute of Arbitrators, Arbitral Women. There is an Indian Women in International Arbitration. You can just, if you don't become members of them, just follow their LinkedIn pages. These organizations are pretty updated on LinkedIn. They'll post about different opportunities. They'll post about different events that are happening, that may be happening around you. And they are also very focused on, like, you can find out about the people who are interested or involved with these organizations, and then you can reach out to them. So again, another way of finding how to build your network. A lot of these organizations, they also have a younger division. So like ICA has a young ICA division, which is arbitration practitioners who are under the age of 40. They are eligible to become members of these organizations. So same as with ICSID, Young Arbitral Women. Now there are these are the memberships that you can consider. They may be paid, they may not be paid, but definitely like for Charter Institute of Arbitrators, I got a membership when I was doing my master's in international arbitration. So that you have to send in the application, you have to send in your resume, but it's easier to get into it. And again, if you don't want to pay the money for the memberships because they are expensive, you can follow the LinkedIn pages and get the best out of it. These are some of the organizations that you can follow, and all of them have newsletters also. So you can go on their website, sign up for the newsletters. That's again a cheaper way to learn about the opportunities. There's this LinkedIn page called Careers in Arbitration. This is quite good. I really like it because the person who manages this account, she posts about, she's an arbitrator herself out of London, and she posts about different opportunities, different vacancies, events happening around the world in arbitration. So you can find out this page on LinkedIn and you can join it. Then again, transnational dispute management. This is one of the more like, I get the newsletter from it, so it's easier for me to keep myself updated with what is happening in different parts of international arbitration. I'm in the US, I may not be able to read everything about what's happening in Singapore or in Hong Kong. So with these kinds of organizations, with these newsletters that I've listed here also, you may keep yourself more updated, and that, of course, the more updated you are, you're going to know about more opportunities. So that is there. So now GAR News is Global Arbitration Review. You can pay for it for their full subscription, or if you don't want to pay for it, you can just sign up for their updates, and they'll send you an update every, I mean, US time, it's evening. They'll every day send an email about what happened with respect to any arbitration in any part of the world. So that is again very, like, if you can just read those headlines, it's amazing to get information about it, keep yourself updated. And you can also send your blogs, your articles to them. Kluwer is also one of the more common arbitration blog websites. Get your articles published there, send in your blogs. These are all helping you get visibility. So someone who's starting out in international arbitration, but you don't know, like, you don't know who is, you are from India, right, and you're applying for a boutique law firm in UK. They don't know your name. How do they get to know about you? When you have published blogs and stuff, they know, okay, there is someone X person over there who, okay, this person has knowledge about international arbitration. I have read their work in blogs and different cases, case analysis. So these things you can follow. Independent arbitrators, I covered that there are different ways you can find them. You can find how to reach out to them. LinkedIn is again amazing source of it. If not, you can also go for GAR 100. So this is the same GAR. They release the top 100 law firms in international arbitration, and you can, and it's not just based on US, it covers law firms all over the world. So you can find law firms in your area, and then you can just do the research, find out opportunities about them, reach out to people over there, talk to them, understand about it. PCA and exit portals, you can find attorney information. So for example, maybe you're interested in talking to someone, you got an interview with someone, and you want to be, of course, be prepared. So you can go on the PCA website and you can search for that person's name, and then find out that, okay, how, in what all cases did this person appear as an attorney, and what are the kinds of cases this person does with. So for example, for someone like me in the US, if I want to find out about law firms or independent arbitrators who are dealing with cases in India, because that is where my expertise lies, I'll go and look at PCA website and see that, okay, in White case, who's the attorney who has been representing India, or who is the attorney who's representing against India, right? So that information you can get from there, and then you have to do a little research about them, and that gives you a good fodder to talk to them. Okay. Build your network. That is one of the, like, major things you have to keep in mind, that you need to build your network. Without building your network, it's not like a sole proprietor. You can just go there, like, you'll have clients coming in. Arbitration people will not come in like this. They will need to know you, they will need to know your work, they will need to know how much you charge, they will need to know how many awards that you have released or given. They have they hold their ground in the court. So all those things that are very important. Now, how to decide the path, right? As I mentioned, I was clueless about arbitration. Forget international arbitration. I was clueless about arbitration when I graduated from law school. We did have William Westmoot, but never really cared. I was more into different part of the mooting culture. I used to do constitutional law moot courts, IP law moot courts. So never really interested in this. But it is one of another ways that to understand, to read about law. If this is, of course, applicable if you are in law school, so you can take courses and gain knowledge about it. Attend webinars and conferences to understand if it interests you. There are innumerable conferences that are happening on a daily basis. They may be free of charge. You can just register for them. You can have webinars. There's a group called Arbitration Week. So it happens in different parts of the world. I have been to some of the Washington Arbitration Week. There is one that happens in last week of November every year. There is a Paris Arbitration Week that just happened, I think, last week. There's a New York Arbitration Week. So you have to keep track of these websites, and you can just register for webinars. So these are free of cost, and they have really good speakers. They cover really good panels, really good topics that are coming up in international arbitration, and that there again you can ask questions, you can understand that is this something that interests you or not. One of the other parts is tribunal secretary path, already discussed it. Speak with practitioners. This is very underrated. People are very scared to ask questions. They are always like, oh, I'm so old already, or I'm so experienced in law. How do I reach out to someone and ask them a question which they may think is stupid? Don't care about it. Just go and ask about it. Okay. So LinkedIn outreach, as I mentioned, I spoke with someone from Freshfields Paris just by like sending this person a connect request, and reached out to him, and he was like, yeah, sure, we can talk in like 30 minutes. A cold emailing may or may not work, because again, arbitration practitioners are very busy because they are like running around somewhere or the other. So it may or may not work, but LinkedIn could be a good way to reach out. GAR news, you can find out about if there's a case like case about India, right? That came into something, some development happened in that, and you want to know about who's the attorney over there. Keep reading about it. Keep following. Maybe you'll be able to write blogs about it. You can reach out to people who are against the company, against the Indian entity. So that again is very, very essential for you to understand. Commercial arbitration or investor state arbitration, they are the broader heads of international arbitration, but they are inherently different, because commercial arbitration, a lot of law firms, they will have people deal with both sections. But there are also, and mostly I've noticed this with boutique law firms, that they are very focused on investor state arbitration, so they'll just develop their expertise in it. And so the law firm that I worked with, they were mostly in investor state arbitration. One of the senior associates used to do commercial arbitration, but they were mostly in investor state arbitration, because there is a certain way of representing a company in investor state arbitration, or there is a certain way or certain arguments that you have to represent when you're representing a country, you're representing a state. So same way, like if you're a prosecution lawyer, you will know the tricks and tips of prosecution, and its difference for defense. Of course, you can do it. The skills are transferable, but that there are niches maintained over there. Lastly, if none of this path works for you, work in the industry and find it out if it's for you or not. And if it's not for you, just leave it. That you have gained certain legal skills over there, which is transferable. So if you want to, from arbitration, you want to go into litigation, it's not like you've wasted those number of years. It is going to still be helpful for you. So a lot of people and a lot of law firms in the US and otherwise also, they don't list themselves just as arbitration practitioners. They will be like dispute resolution, which may include international litigation, domestic litigation, international arbitration. So those skills are transferable, and by the time as you gain more and more experience, it becomes comparatively easier. So I think to summarize now, I want to leave some time for you guys if you have any questions. So the key three takeaways I would say is the ways to start: know your path, how you have to develop. If you're thinking about going for studies, then what is the path you need to take? If you don't think you want to expend that kind of resources and you want to build an international arbitration career from India, think about what are the ways how you can do that. Maybe tribunal internships, tribunal secretaries could be one of the ways. Working with the law firms that are representing big clients, that could be one of the ways. And definitely, this is irrespective whether you want to practice whether you want to practice in India or internationally. You need to read. You need to be updated with what is happening in international arbitration world. Knowledge is something that is going to make you different from the rest of the crowd, and it majorly plays a role over here. So I am very valued for a law firm which has case against India, but I am kind of, I don't want to say the word useless, but I'm not as valuable for a law firm which has only clientele in the South American region, because I do not understand the laws over there. I do not understand what are the developments that are happening there. So be make sure that you are developing the reading habit, make sure you are updated with that. Networking, as it is for any field in the in law, it becomes even more crucial in international arbitration, given everyone, almost everyone knows everyone. If you're working in DC area, you will know which partner is working with which client in international arbitration in the DC area, or in New York DC, or in the bigger US area. So you have to know whom should you reach out, what should your network look like, and where do you aspire to be. It all has to go in a particular manner. It cannot just be arbitrary. Ask questions. Again, I have asked questions in webinars. I always have questions. In classes, I would ask my professors questions. And I don't care, like, if the other person is thinking that you're stupid, let them think. They're not going to come back and build your arbitration career. So ask questions. Arbitration, as we know, it's not one size fits. So you just have to make sure that you are exploring and experimenting and finding the path that works for you. So yeah, that's it from my side. Do you guys have any questions, any comments?
Thank you so much, ma'am. We have few questions in the chat box. Would you like me to read them for you?
Sure. Let me go through it. Okay. Okay, so will this presentation be shared? I can share it. I don't mind sending it to you guys. Um, I am not. So, Minhas, you have asked a question that, firstly, thank you everyone for the questions. Minhas, your question is that you are a Pakistani lawyer based in UAE. Kindly share some thoughts on Dubai ADR. So as far as I know, the Dubai area is very popular with construction disputes, construction arbitration disputes. My knowledge of that area is very limited. Sorry, it may not be very useful for you. But I have seen that because there are a lot of construction projects happening over there. So even there is a smaller niche over there, that in investor state arbitrations you may have an expertise in construction arbitration. Dubai ADR, I know, I think they had some recent event. I can't recall what was it about, but the best way would be to get yourself involved in this community. Even if you're not based out of that particular city, sign up for their email, sign up for their newsletters, and you will be somehow you will be in the loop. So even if you're visiting the city, try to find out time to meet people who are there. Okay. I hope that helps. Sorry for the limited knowledge on that.
Yes, ma'am. Thank you very much. Thank you very much.
Sure. Apart from, so Anshul has asked, apart from what to do, how to maneuver our aspirations in the international arbitration domain, can you enlighten on the part what things we should not do as young professionals? I mean, with that is a huge answer. I'm guessing that what you mean by is what you should not do as a young professional in international arbitration. Is that your question, Anshul? Would it be possible for you to respond? No worries. So the things that you should not do in international arbitration is, don't stick to something. Like, you have to be very flexible with international arbitration, because I mean, to avoid as beginners, is it an international arbitration or is generally in legal field? Yes, in particular. Okay. In international arbitration, see, the more, this is one of those fields where I'll say the more. So first, two things. Don't try to fit in, like, don't forget what your strengths are. So for example, for a very long time, I used to not focus on this fact that coming from Indian jurisdiction, coming from a common law jurisdiction, that was my strength. I would not approach law firms which were focusing on international arbitration, not just because, like, I didn't want to work for them, but I was just like, okay, I'll just reach out to these firms. And after some time I realized that I am more of an asset to a white end case which has a case against India, or which is representing India, than I am valuable, the same thing, to a fresh field. So that is something you have to avoid, that don't run behind the name, understand where you are more valuable. That of course comes maybe with experience, maybe with talking to people, or maybe you just like, you're really smart. That is one thing. Secondly, what was I going to say? When you are deciding on a particular field of where you want to practice, right, in international arbitration. So I spoke with someone, she is working with Covington here in DC, and she worked with Jones Day in Paris for I think 6-7 years. She used to teach international arbitration, and she's basically one face you will see in every international arbitration event. Her name is Shereen Foti. And she told me once that, my question to her was like, okay, you worked in Europe, so do you think I should consider going to Europe, get my foot in the door and come back to US? She was like, see, it seems easier, but it's not actually that easy. Because you will have an argument that, oh, I can work in Singapore and then I can move to UK. Yeah, definitely that can happen, but you may still face challenges. So don't be fooled by the fact that it's just international arbitration, so the relocation process is much easier. Okay. I hope that answered your question. Then Nandina, you asked, ma'am, can you please share your own process of how you became an international attorney? So firstly, with respect to that, see, my journey has been very untraditional. Like even with respect to international arbitration or people who come to the US to do LLM, my journey has been very untraditional. Um, when I was working with KNS, I got a scholarship for intellectual property laws with George Washington. I came here, studied the subject, worked in it for roughly 2 years, and but I felt that I needed something a little more challenging, and and then I was back in India. I started working with startups, worked with one of the on one of the arbitration matters, found it really interesting. I was always interested in litigation, but due to personal reasons I have been relocating quite frequently. So for me, to litigation practice needs you to be in one place. You cannot build a practice, because it's like there is a lot of face value in litigation. So if you keep moving every 2 or 3 years, you cannot build a litigation practice unless you're with a law firm. That too also it becomes difficult. So for me, international arbitration made more sense, that I'm getting to do the litigation part of it. I'm getting to argue. I'm getting to be in that kind of a setting, work in high pressure job. But I'm also getting to I also have the liberty to relocate. So it's again going back that it's not easier. But say if I'm working in commercial arbitration, not in investor state arbitration, but in commercial arbitration within the US, I have the liberty to move from East Coast to West Coast. I may work in New York for a certain number of years, and then if I want to move, I can move to California for the rest of my life. So that's why that's how my journey has evolved. And also for international attorney, I mean, you are out of India, so you are known as international attorney, right? We don't think of ourselves that way, but you need to like just don't go to another country with a broader idea in mind of being an international attorney. Know what you want to do. Okay, no, because it's not easier. You're leaving your home jurisdiction and going to another country to build a network there. In these countries, network matters even more, because this was my experience, and almost every international student I have spoken with is that we are not taught how to build network. We are just like, we focus very much on doing internships, studying in law school, and then that's how it is for us. Here people are more focused on building their network. They will go to these conferences, they will go and talk to people, they'll send cold emails, they'll reach out to people, and that's how they build their network, and that's how they find jobs. So these things are certain things, is you have to know the market where you're going into, and it makes the job easier. Okay. Chandrasekhar, you've asked, what is the scope for civil engineer, say retired? I'll say, like, for, I'm assuming you already know this, but you may be an asset in the construction arbitration field, because they do need experts to analyze the documents, to appear as experts in the arbitration proceedings, and also like for them to prepare their documents. So you may be a value amazingly you may be an amazing addition to any team that is looking for arbitration and is dealing with construction disputes. So for example, I once took a class with someone who was a damages and compensation expert. So now, when you think about damages expert, you'll be like, why do you need to be an expert into that? No, but because arbitration awards are such huge awards, like there has been one of the award which was for $2 billion, right? You cannot you There is a way that you have to come to that conclusion, that number. So over there, those experts matter a lot, and that is where I think you can be very useful to maybe read out things, because arbitrators may or may not be experts in the civil engineering field. Monica, you've asked, I'm pursuing LLB from Delhi University, so how do you enter an international legal world after studying in India? um, it is one of the easier ways is to go through the LLM route. You can find out, it's based on your preference. And sorry, I like to point out that when I was early in my legal career, I wanted people to just give me a set path, that tell me what I have to do. Don't give me this answer of maybe this is how you have to choose, but that's how it actually works. So if you want to work in the US, you have to think about what are the universities that are there, what are the colleges that you can go to, what is the expenditure that you can afford, what is the life after you have done your LLM. It may be visa, it may be bar is a huge issue. A lot of the reason why I started doing bar mentorship is because I see a lot of students getting stuck over there. They're amazing attorneys back home, but they are working as law clerks in the US, or paralegals, because they're not able to get their attorney license. So you have to know which part of the world you want to go to. You want to go to Europe, you want to go to UK, Singapore, Australia, what kind of universities are there, what kind of courses they are providing. Reach out to the faculty over there. So for international arbitration, how I decided was that, okay, what is the kind of faculty that this university has. It has the former ICC secretary. That's an amazing thing. He will have a very great network. And it proved to be true. When people see the recommendation of this guy on my resume, they are like, okay, this person definitely knows international arbitration, so I will at least talk to her. Okay. So these things matter a lot. I hope I have answered the questions. I don't see any more questions. So does anyone have any more questions that I can answer? Also, feel free to connect with me on LinkedIn. You can find me very easily, Sangat Sai. So I'm very prompt on LinkedIn. At times, I'm not able to respond to messages, but I will get back to you. So reach out to me over there. And if you have any questions about international arbitration, also that I may be able to help you with, or just otherwise also with the legal journey outside India, feel free to reach out to me. I feel that there's a lot of knowledge gap from what I used to be and the things that I learned in the journey. If someone had told me before I started the journey, I think things would have been at least somewhat different. I think Ananya had some question.
Yes,
She
ma'am.
raised-
Ma'am, I
Yeah.
wanted to ask you how to basically apply for these international arbitration, not just in India, but internationally as well. There are many institutes which I feel like they do well, but then again, it is very difficult
Ananya, your
to
voice is
get a
breaking.
hold. Hello.
Your voice is breaking. Could you please say that again?
Ma'am, my question is that how to get a hold on these kind of internship easily. Since cold emailing does not work every time, and not every law firm is, replying to everyone. So this is the
Mhm.
biggest question that I have.
See, for the organizations, again, for the organizations, you have to keep a track when are their applications being released. There are number of students that are applying for that, and they may be more qualified than you, because uh, here, like in India, we do have that that okay, you have to do your LLB after this age, right? Like most of us are 12 plus 5 courses, or people do take 3 year courses, but you have done some kind of prior course. Here it is like for me, right? I switched from my IP to international arbitration. I have more experience, so probably if there is a person who is applying from a law school and someone who's looking at my resume may give me preference. So that is one thing you have to be mindful. So there is no set path, set things that you can do. The only thing that you can do for sure from your side is make your resume attractive. If you're not getting opportunity to do internships, do write blogs. No one is stopping you from writing blogs. There are so many websites. You can just send your blogs in and list it on your resume. So as you must be already aware, research papers, blogs, they do add a lot of value, because it is showing that you are someone who can read something, research about it, analyze it, and put it concisely in your own words. So that makes a lot of difference. Secondly, about law firms, law firms may or may not get back to you. That is a very common pattern. Like you can never send an email to a law firm and be like, oh, you'll definitely get a response from them. You have to do certain follow-ups. Like there have been people, I have sent 10 emails, the same person, over and over again, because I wanted to speak with them. And either they'll get tired and responded to you, or after some time you will get tired and stop following up with them. But cold emailing doesn't always work, but that is one of the things that you have to try out, because how else will you reach out to them? You can't catch hold of someone who's sitting in London by being in India. That is the only way. You can maybe reach out to them on LinkedIn. So for me also, like there are people who have not reached out, who have not responded, but there are people who have responded. Another way could be, so on LinkedIn, find connections. So sorry, if you have someone who's like maybe working with another field, another department of a law firm in the country, right? So you have a friend who's working with a boutique law firm which does international arbitration and does IP. Okay, so reach out to that friend, ask that friend to introduce you to someone in that international arbitration department. Those references matter. They matter a lot. You may feel like that, oh, why should I reach out to that person because they are not working? No, but if you are coming to me from a reference, I may uh, give slightly more attention to you. The possibility of me responding to your email or question may be much higher. So that is what you have to do. There is no set path. I'm sorry to give you that answer, but that is the true reality of it. Okay. Vani, did you have a question? I thought you unmuted yourself, or no. Okay. Any other questions anyone else has?
Silence.
No, ma'am. I believe that all the questions are wrapped up.
Mhm.
So thank you, ma'am, for such an insightful and engaging session. Now I would welcome our respected faculty convener, Dr. Shobita Srivastava, to conclude the
Mhm.
session.
Sure. Thank you again, everyone.
Uh, I'm Dr. Shobita, the convener for this workshop. I'd like to thank each and every of the speakers who are here for explaining this wonderful concept and also diving into the practical aspects. It is with great pleasure that I come here with a great deep of intellectual satisfaction as well to deliver this thank you speech to our two speakers for the day, Professor Dr. KVS Sharma and SQ Sangmitra Sahai. Both of the lectures were actually the practical insights. And like I have always said, that we have frequently had these sessions on the theoretical aspects of arbitration. We also teach in class the particular theoretical aspects which our students learn and grasp on, on an academic basis. But it's actually important to have the practical insights. And what you presented, Sangmitra, ma'am, that is actually filling the void and gap, and has given our viewers an insight into how can we actually enter the international arbitration area. I'm sure that you'll come and agree to come for our subsequent sessions, where we may organize a specific session whereby you may in detail tell us how to actually carve a career in arbitration, in international arbitrations from US, and when we belong from India, and how to go in US for further studies specializing in arbitrations. Thank you again for joining us, especially when you are joining at, I guess, 2:30 a.m. now.
Yeah.
Okay. In a different
I
time
had
zone.
another cup of coffee, so that's okay. But thank you so much, Shobitav, and thank you for the viewers also for joining. I'll be very glad to help anyone in whatever way I can with respect to international arbitration or with respect to coming to the US also for further studies. That is one thing I've definitely learned through this journey, that reach out to your network. Even if someone is not in your network, reach out to them and ask them questions. So thank you for organizing this and thank you for your invite.
Thank you again. Thank you, and it was good to have you today. So I also thank all my participants. We shall meet tomorrow at the same time as in the 10 a.m. We'll have 3 sessions tomorrow. Thank you for joining the day one of the workshop. We shall end the meeting here. Thank you, ma'am. Thank you for coming. Bye.